Today marks the beginning of a series of webinars, each designed to delve into critical aspects of the property sector. We are happy to have you join us for this session and look forward to your participation in the exciting and informative session planned for the upcoming weeks. Before we commence, I would like to introduce our esteemed speaker for today. Featured on our event flyer, we are honored to have Dr. Kenneth Donkor-Hyiaman with us. Dr. Ken is not only a respected lecturer, but also a seasoned expert in real estate development, finance, and law, hailing from the Department of Land Economy at the Kwame Nkrumah University of Science and Technology. With over a decade experience in real estate sector, Dr. Ken brings wealth of knowledge, particularly in land acquisition in Ghana. His insights will be invaluable, especially in understanding how to purchase land without the risk of future litigation, thereby safeguarding our life savings. To get into our conversation today, it will be important to put some opening questions forward to our resource person. What really is land? Majority of us probably know land to be what we build on, but there is many angles to what land actually is, and it will be really good to take us through and help us understand different types of land to be acquired in Ghana, who has the capacity to alienate these lands. Without further ado, I'm pleased to invite Dr. Kenneth to lead us into our first segment. Thank you.
And thank you, Godwin, for this opportunity to talk about land, especially the buying of litigation-free land. And it's quite interesting. In preparing for this webinar, I've had to consult quite a number of materials just to make sure that we have accurate information, not only from our own experience, but what other researchers and other consultants have worked on, right? And so it is quite interesting. And I would like to start with the question you posed. What is land? And it's quite interesting because whenever I interact with the ordinary person, the layman, the view I get is that land is essentially the surface soil, or that part of the earth covered by water. The truth is that that definition, although it's necessary, is not sufficient. I mean, from an economic and legal point of view, it's just not sufficient for anyone who wants to transact in land. And so I would like to delve a bit deeper into what land essentially is, and of course the implications for not knowing what land is. And the first reference material I'd like to draw your attention to is our very own Lands Act of 2020, Act 1036, right? And when you go to section 281, that is the interpretation section, a definition of land is provided. And here you will see that this definition is not even exhaustive, right? And so land is even much more complex, as we would see. So I would like to read what section 281 of the Lands Act. And here it says that land includes the soil, the solid surface of the earth, plants, crops, and other vegetation, a part of the earth covered by water, any house, building, or structure whatsoever, and any interest or right in, to, or over immovable property, right? So, I mean, from the way the definition is couched, you can see that in fact the writers of the act didn't contemplate an exhaustive list of things that will constitute land. And you would also realize that land per this section of the act, or per this act, essentially goes beyond just the surface soil, right? And it is important I make these 2 points. There are some interesting things we just have to know, just based on this definition of the act. You will see that there are certain things that are also classified as part of the land. So like trees, plants, crops, vegetation, and so on. They are all classified as part of the land. And this is based on some principles in the law of property that I into account. And so there is a doctrine called the ad coelum doctrine in property law, which argues that land does not only include the surface soil, but anything above it and beneath it, right? So anything on the surface of the soil, anything on it, beneath it, is part of what we will classify as land. Then again, there is another doctrine which provides that any or attached to the land in a permanent manner is also classified as part of the land, or it's also classified as land. And even more importantly, and you'd realize that essentially touches on the physical dimensions of land, right? So the surface soil, anything that is attached to it, anything that is affixed to it, will usually be physical things. But then that is not all. In identifying property, we need to look at the legal definition of land. And usually that will be made in terms of the rights and interests that people hold in the land, right? And so let me do a very quick sort of a summary of what I have said. So essentially, land would include not only the surface soil, but then would include everything above and beneath it, right? You would see that it will also include anything that is attached or affixed to it. And lastly, it will also include the legal dimensions, which is the rights and interests that are held in that parcel of land. So that brings us to the different types of interests that can be held in land based on Ghana law, right? And once again, if you want to know the different types of interest, one of the most important laws you need to consult is still the Lands Act of 2020, Act 1036. And in this act, there are 5 different categories of interest that can be acquired in land, right? So you have what is called the allodial interest. And this allodial interest is essentially the highest form of interest you can acquire in the land. And this is vested in certain groups of people you typically refer to as the land holding groups. So they are essentially the stools, the skins, the families and clans, and in some rare instances, you have individuals having the allodial interest. Terms, which also include freehold interest. So the Lands Act provides for 2 different types of freehold interest. You have what is called a customary freehold, and this customary freehold, it's what usually would be acquired when someone purchases land outright, right, from the allodial title holders. And then you have the common law freehold, which is land that is acquired based on common law principles, right? And following that, you have the usufructuary interest. And this usufructuary interest usually is given to people who are subjects of the stool or the skin, or members of the land owning groups. It also has a sort of a perpetual ownership in mind. And usually when a member or a subject of a stool or a skin finds an unappropriated portion of land and goes to develop it, usually with the permission of the trustee of that stool or skin, then he may hold that land as with a usufructuary interest in there. And then there are lesser rights in interest in land that an individual may hold. So the leasehold interest is a very common type of interest that we hear of quite often. It has become very common because as per Ghana law currently, to a large extent, the freehold interest may be difficult to acquire. Indeed, the law or the legal position currently favors the granting of leaseholds, as we would see later on. Usufructuary interest is usually granted to subjects of the land-owning groups, usually the stool or the skin, right? And it would usually be acquired when this subject develops an unappropriated portion of the land, usually with the consent of the trustee of the stool or the skin, right? And this type of right operates just like a freehold because you can essentially hold on to the land forever, and it's alienable, it's inheritable as well, right? And then the most common type of interest I find in Ghana is a leasehold. I mean, a lot of the interest that many people hold in land today are leaseholds, right? And a leasehold is essentially an inferior interest in land. We would typically say that it's a wasting asset because it is terminable. It will end at a point in time, unlike a freehold or an allodial interest in land. And there are different forms of what you refer to as a leasehold interest. So the very first one is what you call an estate for years. So it is very common to hear people say that they have acquired, say, a 99 years interest in a piece of land or property somewhere, a 50 years interest, 60 years, and so on. Example of an estate for years. And then you have periodic tenancies. So sometimes some landlords will grant the use of their properties on a monthly basis, and those can be classified as a periodic tenancy. And then you have a tenancy. When your tenancy agreement expires and you don't renew it, but continue to stay in the property, you are staying there at sufferance. The landlord can kick you out at any point in time, right? And then you have a tenancy at will, which is usually the case when you stay in someone's property without an agreement, and there's a certain understanding that the landlord can kick you out at any point in time, right? So that is a tenancy at the will of the landlord. And then you have customary tenancies. Typical examples are a busan and a bunum. So they are usually created with some agreement or understanding that some physical assets that will be produced or generated will be shared in certain portions, right? It may be food crops that may be grown on a parcel of land, and these produce will then be shared between the landlord and the farmer who cultivates these parcels of land. Yes. Now, this brings us to the different types of lands you would find in Ghana, or that can be acquired in Ghana. So it is not just enough to know what kind of interest you can acquire in land, but essentially you also need to know what types of lands exist that can be acquired. So in Ghana currently, lands can be classified into three main groups, right? Or let me simplify it, let's say two. So you have what is called the public and vested lands, and then you have the private or customary lands, right? So the public lands are essentially the lands that are owned by the state. It is believed that this constitutes about 18% of all lands in Ghana. And then the vested lands are those lands that belong to certain private people, for instance, schools that have been vested in the president on behalf of those people. And sometimes this may be necessary because there's conflict in terms of the ownership of those lands. And so the legal interest is vested in the president on behalf of that community. And then the equitable interest in the land then vest in the or the beneficial rights then vest in the people who actually own that type of land. Now, the bigger part of all lands in Ghana are customary. It's not enough to know what kind of interest are acquirable, right? But then it's also important you know the different types of lands that exist. And interestingly, you know, as we move on, that the different types of interest I talked about what is called the public invested lands, and then you have private or customary lands, right? This constitute just about 18% of all lands in Ghana. And then the vested lands constitute about 2% of lands in Ghana. So public lands are essentially lands that are owned by the state for on and behalf of the citizens of Ghana, right? And the vested lands, they are lands that are, they are usually private lands that have been vested in the president on behalf of certain land owning groups. And there are two key reasons why some lands have been vested. Lands like some portions of the Sunyani lands, the Winneba lands, and even the Nkoko lands are all vested lands. And there are two key reasons. One is that there's a conflict in terms of the ownership of those lands, right? And so in order to put those lands to productive use, the state can vest them in the president, make use of them, and then distribute the benefits to the contesting groups. And then sometimes lands may also be vested for planning purposes, right? For planning purposes. Now, you would also realize that private lands, which constitutes the bigger chunk, about 80% of all lands in Ghana, can actually be classified into three groups. So you have stool lands and skin lands, you have family and clan lands, and then you have individual lands, right? And for each of these three different groups of land, you would find that there are different processes that you need to go through in order to acquire them. Very often, in my experience, conflict arises when people are ignorant about what type of land they are acquiring and hence do not go through the necessary due diligence processes to acquire them. Right. So as we move on, we will see some of these things. Through ignorance, some people thought they had bought a freehold interest in land when actually find out that what they had been given is a leasehold. They start a process of litigation with the vendor. There are also instances where some people paid money for 99 years leaseholds, but got only 5 years, and only found out later when the allodial owners re-entered the land. You get it? So this is a typical case of a secondary sale. So there's someone who bought the land from the allodial owners, and when he had just 5 years on a part interest in the land, he decides to sell it off, and he decides to frame the land as if it's a 99-year leasehold, ends up taking money for a 99-year leasehold and actually gives out. Yeah, so I have also seen instances where people got leaseholds with what is called positive covenants to develop the land over a certain period of time, which they actually didn't know, only for the vendors to re-enter those lands. And this is quite common. So when you buy land, usually the chiefs will tell you that develop the land within 2 weeks, 2 years, 3 years, and so on. And for many people who are only interested in acquiring the physical land, they ignore these covenants. And eventually, some of the chiefs take advantage of those covenants and re-enter those lands at some point in time. I have also seen that instances where people also got instances where the allodial holders re-entered the land after long periods of non-payment of ground rent. So it is the case that when you buy leaseholds, right, usually you pay a premium and you are required to pay ground rents, periodically, usually I think per annum, to the allodial title holders. And this payment of ground rent is an acknowledgement that you don't actually own the land outright, but then someone owns the land, and so you are making certain payments to that person. And so if you default in the payment of these ground rents, it could be grounds for this allodial title holders to re-enter those lands one way or the other. And this is very, very, very interesting. Sometimes many people forget that they have to pay ground rent. And in the case of a tertiary sale or a secondary sale, where someone already acquired a leasehold and is willing to either assign his or her interest to you or even grant you a sublease, right, of his interest in the land. What may happen is that if for a very long time that person has not serviced his obligation to pay this ground rent, these ground rents may become liabilities that you, in certain circumstances, may have to pay in addition to the premium you pay for the land. And so it's important you know what kind of liabilities already exist, what kind of covenants whoever is a vendor has gone into, because it might, in some circumstances, affect your interest in there, or it could even create liabilities for you eventually. There are also instances where people got leaseholds without some other people have certain rights to the same land. So in a right to pass on the land or to perform certain activities on the same land. But usually when we buy land, we want to, wall it, we want to exclude other people from using it without knowing that all of these concurrent rights may even exist in the same parcel of land. Yeah. Okay, so I'll pause here, and then if there are any questions, I'd like to take them. What I've attempted to do is to give us just an overview of the nature of land, the interest that can be acquired, and the different types of land that can be acquired in Ghana. Yeah, so Godwin, over to you.
Thank you very much, Doc. That has been a very insightful one. Yes. Although the network messed up with us a little bit, but I think now it's better. So please, if you have any questions, you can put up your hand and then you ask. Also, you can use the reaction button. Yes. And then you put up your hand. We call you to ask your question. Also, I have just a few questions here that possibly Doc would have to address. before we move to the next stage in our discussion. Yes. So, Doc, you spoke about family land, stool land, and all of that. Um, who has the capacity in those instances to alleviate such lands? Who are we looking at if we want to purchase such lands? Which individuals are we targeting to maybe say, okay, we want to buy this land, we want to buy that land? Secondly, uh, when it comes to,
Maybe I should take this one. Let me
okay.
let me take them one by one.
Okay,
Right?
all right.
I think that will help. Yeah. So, who has the capacity to alienate land, or let's say to sell land? Right. As I indicated in the presentation, different types of lands and different will require, right? So when you pick public lands, for instance, these are lands that are managed by the Lands Commission, right? And so in terms of capacity, is the Lands Commission that would have the right to give out those lands. If someone purposes to sell land to you, and you find out that those lands are public lands, and that person is not the Lands Commission, then quite clearly that person is trying to defraud you, because the lands in trust for the people. And so it is that occupant of the has the capacity to alienate the land. But then there's a very important point to note. That person cannot do it on his own without the concurrence of the principal members of the stool. You get it? So the occupant of the stool, together with the principal members of the stool, must agree to alienate the land to you before you, they can do that. For family lands, it is the head of the family and the principal members of the family who have the capacity to alienate the land to you. And then in instances where individuals own the land, then they can alienate or sell that land to you. Yes.
All right, Doc. Thank you. Thank you. So what it means is that one cannot acquire land without the endorsement of both the principal members of the family and the family head. Is that right?
Yes. So essentially, the point is that the principal members must concur, right? They must agree to the sale or the transfer of the land to you. They must agree. But it is very important to note this. One of the things that emerges is that, okay, can the head of a family, right, sell land without the concurrence or and the assent of the principal members? Yes, the head of the family can do that in certain circumstances, right? Usually, if he does that, in law, we would say that it is not void, right? As in the transfer is not void, but then it can be voidable in a sense that if the principal members of the family were not consulted by the head of the family, or in other words, they were ignorant of the transfer of the land to the buyer, then they can take steps to set aside that arrangement, right? And so there are a number of what do you call cases in Ghana law that supports this position. So I think there's one case like Beyedi and Mensah somewhere in 1878. And it is the case that can be done. But then also the question that also arises is that, can the principal members alienate land without the permission or without the knowledge and agreement of the head of the family? And the answer is no. The head of the family is indispensable, right? And so the principal members, if they have an interest to alienate some portions of the family land, must get the permission of the family head before they can do that. But that also brings about another interesting thing. So there are instances, I have come across instances where people have bought land from ordinary members of a family, not the principal members of the family. So there were people who posed as members of a family and went ahead and sold family land to people. Now the question is, do those ordinary members have the capacity to sell land to you? And the question is a no. They must either be they must be in this category to have the capacity to sell land. Either they are the head of the family or they are principal members of the family. And even that, they must come together with the head of the family to be able to sell the land to you. That is why it's important. When a head of a family sells land to you, one of the things you want to do is to go and meet the entire family, right? Meet the principal members of the family to be sure that they have agreed to the transaction.
All right. Thank you very much for the insight. But Doc, a quick one before we proceed to some other questions that are available here. Prior to the Lands Act, there are two systems that were available: the family land and the stool or skin lands. The idea was that you touched on that actually. The idea was that you can acquire a stool land, you can acquire freehold in family lands, but stool lands you can only get a leasehold interest in it. I think if you can speak to that point a little more, because we have the Lands Act, which is abolishing the acquisition of freehold in both lands, so that probably our audience will have that clarification. Yeah.
Okay, so this is interesting. Since I think the 22nd of August 1969, there was no way you could, a non-citizen, for instance, could acquire a freehold interest in land, right? So what that actually meant was that some form of freehold, perhaps the customary freehold, could still be granted, especially, I mean, the usufructory interest, one way or the other, could be granted to subjects of the stool or the skin, one way or the other. And then the Act, the Act 1036 then comes in with a stricter provision, which now says that freeholds in stool lands and then family lands cannot be granted again. You realize that this is important because what has happened over the years is that you find some family heads and some principal members of families selling off family land outrightly, and that means that the family loses those lands, which eventually leads to poverty and deprives the future generations of that family of land, right? And so in a way, it is a provision that seeks to protect the interest of not just the present generation, but also of the future generation, right? And one way or the other guarantees them some form of access to land in the future. Yeah, so that provision exists in our laws currently. And so if someone purports to sell to you a freehold interest in a family land, right, especially if you're a foreigner, you are not an indigent of those areas, then you may want to seek the advice of professional, because that may be classified as void, right? And if it's void, it means that it's just not enforceable. You cannot enforce it.
All right, Doc. Thank you very much. So in recent times, there's also this idea of regularization and divesting, where people who are occupying state-acquired lands can apply for the state to regularize them and give them that legal stay on the land. And also, the state is also giving back lands to people by the people, some of the vested lands, they are divesting and giving it back to the families and the stools that they have acquired them from. Is there in any way that this could affect somebody's land acquisition? And also, how should individuals be prepped towards acquiring lands that may be having some of these issues involving the state?
Yeah, so it is a case that the government or the state acquired lands from, private people, stools and skins some time ago for certain public interests or in the public interest. Usually these lands are used in the construction of roads, provision of housing and infrastructure and so on and so forth, right? Now, it is the case that over the years, some of these lands have been encroached upon. And you will find that it is the case that people have built houses on some of these lands. So, I mean, listening to some officials of the Lands Commission, sometimes what they do is that because the state also has a sort of a responsibility towards the welfare of the people, particularly in terms of housing. If is a case that the encroached land has been used for housing, then in one way or the other, yeah, the responsibility of the state in terms of the provision of housing is being achieved. And so if that land is not required, immediately by the state for the purpose for which it was acquired, then they may want to consider regularizing the interest in that land for those who have encroached on the land, one way or the other. But it is not guaranteed that if you encroach on state land, it will be regularized for you. And so you should take notice of that, because sometimes what a lot of people do, and I have heard people say that, once it's state land, just go and start building on it. And once you start building on it, at a point in time, the government will regularize it and then will grant you title or will give you some lease in that land. That is a very risky strategy to adopt, right? At least if such a thing exists, you should consult the appropriate institutions to get a sense of what the plan is for that land before you go ahead with such acquisitions.
Thank you, Doc, for the insight. But then again, there is this issue of people going in to purchase lands that they have to do some searches at district assemblies to know the development plans, and sometimes people end up buying the land, and at the end of the day, some developments come up and they will tell you we have to construct a road through this. We have to do so. A lot of those things. How do people at least arm themselves with the knowledge of future development that could pass through wherever they are purchasing their land? And yes, how will people be able to do that and actually live in their houses with peace going forward? Yeah.
No, so you see, this is part of the due diligence process you need to undergo when buying land, right? So the state has a responsibility to provide infrastructure. And a part of that responsibility is our communities, right? And so you may have bought land, you may have acquired a leasehold, but the right to develop be consistent with the plan of that area. You get it? And so it is important that whenever you plan to buy land, you must also, as part of the due diligence process, check with the planning institutions. Usually the district assemblies, the land use and spatial planning authority, to know what the future plans are in terms of development for those areas. And you also want to know what the zoning of that land is. Has it been zoned for the use that you are buying it for? Because sometimes you may be buying residential land, but it has been zoned for something else. Maybe it has been zoned as a refuse dump. You end up buying it and you may not be able to use it for your residential development. Yes, so it is one of the things we must always consider whenever we are thinking of buying land.
All right, thank you very much. I think where we've gotten to now, we'll be getting into the second segment. But before that, I want to remind everybody that the PropIntel will be here to actually support you in some of the processes you go through to purchase your properties, the due diligence, investments. If you want to do major investment, PropIntel has the expertise to guide you and take you through major models that could reveal the potentials of your investment. Yeah, so at the moment, we also have at the Department of Land Economy some programs that are running in case you want to gain some insight, deeper insight into the challenges, the issues in the property sector and how to get your way through. You want to build a profession in that area. We have MSc Facilities Management, which is also there. You can apply, get onto the website of the school and check the requirements and put in your applications as well. We have MSc Real Estate also available there, which you can apply. Land Governance and Policy, it's also available there. These are all 12-month programs, and they will give you detailed insight into the investment arena in Ghana, property investment arena in Ghana. We have PhD in Land Management and Governance. This could also give you, it's 4 years program, which will give you PhD in Land Management and Governance. So that is all for that.